Welcome to another X Space hosted by Democrats for an Informed Approach to Gender. I'm Ellie, DIAG's Executive Director. First, a little housekeeping. DIAG is a 501c3 nonprofit organization of lifelong Democratic voters. Our mission is to shed light on the harms caused by gender ideology, the medical scandal of so-called gender-affirming care, and the erosion of women's rights. We're working to shift the narrative among fellow liberals. You can learn more about us at diag.org. That's di-ag.org. And while you're there, check out our merch store. And if you'd like to help expand the work we're doing, please hit the donate button. And I'll mention that our donors allowed us to support and sign on to the amicus brief noted by Justice Thomas, brief for larger detransitioners community. So we're pleased that we're able to help boost the voices of those who were harmed by this so-called care. Well, the Supreme Court has spoken. The state of Tennessee is within its constitutional rights to ban puberty blockers, cross-sex hormones, and surgeries for gender-distressed minors. The court ruled along ideological lines 6-3 in United States versus Skrmetti. Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson dissented. The majority opinion, written by Chief Justice John Roberts, stated that Tennessee's law does not discriminate on the basis of sex, as the plaintiffs contended. The majority further ruled that states must have wide authority to regulate medical procedures where there is scientific debate about their safety and efficacy. The court declined to recognize people who claim a transgender identity as a legally protected class. We've reconvened our legal eagles to explain the ruling, and we'll ask about its relevance now that the Trump administration has pledged to defund institutions that practice pediatric gender medicine. We'll also ask about how the ruling might affect other demands of transgender activists in this new political climate. So let me introduce our team. We welcome back civil rights attorney and self-described radical feminist Kara Dansky. She is author of The Reckoning, How the Democrats and Left Betrayed Women and Girls. Also joining us is attorney and DIAG member Glenna Goldis. She writes about the transgender phenomenon on her Substack, Bad Facts. And we're honored as well to have Elspeth Cypher. She's a retired justice on the Massachusetts Supreme Judicial Court. She's now on the board of directors of the Women's Liberation Front. Kara, let me start with you. Please remind us what the plaintiffs were asking the court to do. So recap, if you will, their argument.
Sure, thanks for having me. So Tennessee enacted a law that prohibits the administration of puberty blockers, opposite sex hormones, and surgery for minors. The plaintiffs were 3 minors who call themselves transgender and their parents and 1 doctor. The initial claims brought by the plaintiffs were that the law violates the minor's right to equal protection under the Equal Protection Clause of the 14th Amendment. And the parents had a claim that the law violated their due process rights under the Due Process Clause of the 14th Amendment. And they won before the district court. And the Sixth Circuit did something very interesting, which was grant Tennessee's emergency motion to consider an appeal. And when they granted that, they did something else very interesting, which in a way sort of asked for amicus, for organizations to weigh in, and a lot did. And then in September 2023, the Sixth Circuit ruled against the minors and their parents and the doctor on both the equal protection and the due process claims in a very interesting and, in my view, well-reasoned opinion that ruled that the law is not in violation of anyone's equal protection or due process rights. And it treated the plaintiffs basically had 2 claims under equal protection. One was that the Tennessee law is sex discrimination on its face, and the other was that, quote unquote transgender minors constitute what is called a quasi-suspect classification for equal protection purposes. And we can get into what that means if you'd like. But basically, the bottom line is that the Sixth Circuit rejected both of those claims, as well as the parents' due process claims. And the plaintiffs are represented by the ACLU. But by that point, the United States government had gotten involved and moved to intervene in the case. And after the Sixth Circuit ruling, the ACLU asked the Supreme Court to review the Sixth Circuit's decision. The United States also asked the Supreme Court to review the Sixth Circuit's decision, and the Supreme Court accepted the United States petition, but not the ACLU's petition, which meant that the sole issue before the Supreme Court was equal protection. The United States did not pursue the due process claim that the parents had brought. So that brings us to the Supreme Court. Is that good?
Oh, sorry. The argument was that part of the argument was this idea of sex discrimination. There was a whether or not the ban discriminated on the basis of sex because that the ban treats boys and girls differently. A girl who identifies as a boy can't receive a prescription for testosterone, but a boy who had some kind of hormone deficiency could. That was the kind of the gist of their sex discrimination case, correct?
Yes, correct.
So, okay, let's go to Glenna. What did the majority have to say about this?
The majority looked at both those arguments, whether this discriminates by sex, whether it discriminates by transgender status, and it just said no to both of those. So it said this law does not discriminate by sex. It doesn't distinguish between the sexes. The ACLU is being really literal there, where it says, oh, because girls can't get this drug and boys can't get drug, that's a classification by sex. The justices in the majority say, no, you have to give it a more holistic view and say, like, what's the medical treatment really about? And in that sense, it's treating people the same, whether they are male or female. So it's not a sex classification. And they go into how if it were a sex classification, then so many other laws would also be subject to this heightened scrutiny. And they say, we're not going there. And then as to transgender status, they also say, and this is a little bit of the way they construct it, maybe actually not so, well, I'll get to this later. But yeah, they say that this is not discriminating by transgender status because you have trans people, so-called trans people who want these drugs. You also have so-called trans people who are not seeking these drugs. They do a little thing and they say this isn't really distinguishing by transgender status. So then their next step in the analysis is to apply the test. And the test here is low because, again, this discrimination is not happening on either count. So that just means that the state faces a rational basis review of the laws. That's a really hard standard for the plaintiffs, the ACLU, to meet to say that a law is irrational. And the court goes ahead and says they do not make that argument here. They're not able to do it. And so it just kills the claims.
And I mean, that claim that they were proposing that so many medical treatments are sex specific. It doesn't make sense in the medical context where sex is applied often because of how drugs interact with male versus female bodies. And it's hard to believe that was the extent of their sex discrimination case.
Yeah, that's right, and that comes up in the dissent as well. But and I'll talk about it later with Sotomayor's dissent. But yes, it is something that would have taken us into sort of extreme territory in terms of what could end up in court and be fought over.
And to be clear, the court did not rule on the medical merits of these interventions. And I know Justice Thomas, in his concurring opinion, really took pains to sort through the scientific evidence and talked about the CAS review and WPATH files and all this. So do you think that this aspect of it, the fact that this evidence did come up, do you think it'll carry any weight in the public debate, or will it just be, dismissed as it happens typically? Like, does it matter that Clarence Thomas brought these issues up?
I think there are some people for whom it will matter. So, yes, you're right. It doesn't really come up in terms of the legal argument that the majority has to make because, again, it's such a low standard that Tennessee has to meet, rational basis, that they don't need to prove that these are like the most dangerous drugs ever. And so the majority doesn't get into that really. Where that comes up is Justice Clarence Thomas, where he says, this is just important for everyone to understand, so I'm going to do it. I'm going to lay this out there. Of course, Justice Thomas has a reputation as being far right. Liberals do not like or respect him. Centrists also view him probably as kind of extreme. So, it's not helping us too much on that front, but it is like one more forum where these points have been made, which is good. And I think there might be a category of conservative people who are, maybe the type of people who read the Wall Street Journal and they're conservative in some ways, but on social issues, they're kind of moderate. They don't understand this gender stuff. But then they see this justice who they respect, Clarence Thomas, and he's making these really sharp points, so it gets their attention.
And he didn't. I mean, it wasn't necessary at all for him to do that. They could have just ruled specifically because the opinions are really clear, and it's not necessary. So I'm a little curious about why he went to that trouble. Is he just really interested in it, or was he making a point about these interventions? Did he want to get this in?
Yes, that's right. He wanted to get it in. I mean, with all these concurrences, they have points that are important to them, and that's why they're bothering to do a concurrence. And you could hear that in oral argument that he had tough questions for the Solicitor General of the United States, who at that point was on the side of the ACLU. So he's read up on that. I mean, you can tell that he and Justice Alito have kind of followed this in the news, and like they're mad about the harms that are being visited on minors.
Yeah. Okay, we'll go to Kara. The plaintiffs also argued that Tennessee's law showed preferences for people who conform to gender stereotypes. What did Justice Roberts have to say about this?
Yeah, Justice Roberts pretty much dismisses this because it's pretty clear to everyone involved that that medicalizing young people's bodies has nothing to do with expressing a preference for sex stereotypes, unless you think, which the ACLU might, that having a sexed body is itself a sex stereotype. But beyond that, he only spends a couple of paragraphs on this because it's pretty easy to refute the idea that banning drugs for minors doesn't really have anything to do with sex stereotypes. I realized I meant to say something in answer to the first question, which is kind of important. This case ended up not touching surgeries. So I'm seeing a lot of people saying that the Supreme Court has ruled that Tennessee may ban puberty blockers, wrong sex hormones, and surgeries for minors. That's not the case because early on in the litigation, I think before the district court, it was found that these plaintiffs did not have standing to challenge the state law ban on surgeries because none of them were in fact seeking surgery. Now, I will say, I suspect that if the surgery question comes before the same court, the ruling will be the same. So I don't want to suggest that there's somehow something wildly different about surgeries. I'm just saying it's not accurate to say that in this case, the Supreme Court said that a state can ban surgery. But as to the sex stereotyping, Justice Roberts just handled that in like 2 paragraphs and basically said, no, that's ridiculous.
Right. Yeah, that was very clear. Let's go to Justice Cypher. So I understand today's ruling means that the restrictions on pediatric medical interventions passed by 24 other states can stand. And it also means that other states have the right to allow them. Am I getting that correctly?
Yes, you are. This is a position of the court that certain things belong to the state and not to the federal government, and that medical care is one of them, and as well as setting age restrictions on things. And what I thought was interesting about Robert's opinion, the way he framed it, was that he really just said, push everything else away. This is an age and medical care classification, and the state certainly has the right to do that. And of course, if they had gone the other way, they would have been in complete contradiction to Dobbs, which said, this is a matter for the state, not the federal government. So he avoided a lot in that majority opinion that I think some of the other opinions filled out for us and kind of helped. So yeah, I think there are 22 other states, I think, who have bans, and they should be fine. And yes, states can allow them. The states that do, they can.
So we would see these challenges from the ACLU every time the state bans. The ACLU is right there on them challenging. Does this mean that's done? No more challenge?
I don't know if you could ever say that there will be no more challenges on anything. There may be some language that they can use to find that it shouldn't apply in a certain circumstance, or maybe they'll take the next age cohort, young adults, and challenge it on that way. I don't know. They can always try, but what this does is it gives the judges sound basis to rule, and they have Supreme Court guidance on it now. So it's not like the circuits are all making up different analyses or tests or anything. We've got one from the Supreme Court, and so that's very good.
Yeah, significant. But I can see that there's more challenges ahead, and
oh yeah,
be back where we started in certain aspects. So, does this conflict with the Bostock ruling, in which the court ruled that an employer cannot discriminate against employees who claim transgender status?
I don't think it does, because Bostock was based on a statute, the federal statute, Title VII, that barred discrimination on the basis of sex in employment. And the author of the opinion, Justice Gorsuch, was very careful to say this only applies here in Title VII. And he didn't want it to apply to equal protection, and he didn't want it to apply to Title IX. But of course, litigants took it there. The administration, the last administration, and the Obama administration took it there and expanded it. So it's given a lot of cover for people who wanted to push the law. But it doesn't conflict with that, because again, that Bostock was based on a statute. This was a constitutional challenge that Robert says doesn't really meet constitutional requirements because it's age and medical care. What I think is interesting in both the majority and in Bostock was the term transgender status, and also how Chief Justice Roberts referred to transgender people and transgender children, transgender boys, the adoption of the language without thinking about it deeply, or just accepting that there is such a thing as transgender, that it is gender identity is actually something that one can say is real. That seems to be a premise accepted.
Yeah, that was, in reading the decision, that was kind of the first thing that stood out for me, was that once again, none of this was defined. Everybody accepts there's a gender identity and that that's somehow valid, and that there are these transgender people. I mean, right from the start. And do you think that was, is there, when they're making these decisions, are they thinking about that language? Are they using those terms purposefully, or is it just they're so used to them and that's what everybody understands?
That's a really good question, because what I think in this case is that they use these terms consciously, at least Roberts did, because I suspect if he hadn't, he might not have kept his majority, or he might have lost Gorsuch, because Gorsuch framed transgender status and made it a classification under Title VII. And so maybe they needed to not ruffle that that too much. Some people speculated a lot about how he didn't write anything, and I stuck out his here, and
Right.
I don't think that's true, but
Yeah, hard to know. Okay. So we'll stay with you, Justice Cypher. How did the court address the question of whether people who claim a gender identity different from their sex are a protected legal class?
Well, the court, I don't think that, as we said, as Kara said, Justice Roberts discussed sex, dismissed it. But if you read maybe Amy Coleman, Judge Barrett's opinion, her concurrence, or Judge Alito's, or and to some extent Judge Thomas's, although he really did focus hard on evidence and medicine, Justice Barrett took us through a straight analysis based on sex, and said, this is not sex because she said this is not a suspect class. You need to have constitutional scrutiny. You need an identifiable group. And even during oral argument, the ACLU argued that, some people step out of the gender binary, or there's fluidity, or there's non-binary. So right away, the ACLU is saying, we're not an identifiable group. That also means they're not an immutable group, which means is it something that can change. And originally with African Americans and the 14th Amendment, and then with women in the 14th Amendment, whether you're Black or whether you're a woman, you can't change that. It's not your fault, in other words, that you're a woman. You just were born that way. So that's the thinking there. And then also she pointed out that a group to meet this kind of criteria needs to show that they were politically powerless, and they can't show that because they had the administration on their side, they had the ACLU on their side, they had a lot of money on their side, and they had a lot of political power. And she also pointed out that the discrimination has to be in the law. It can't just be, I don't like you, so I'm not going to give you a piece of cake or whatever. It has to be legal discrimination that you suffered for years, such as hundreds of years, African Americans, hundreds of years, women, thousands of years. So I think that's how she handled it and dealt with it. But other than Robert saying, this is not it, this is not sex, this is age and medical care, and then I think Judge Barrett just gives us a really nice explanation of the law in this area.
Yeah, very clear. So, what does that mean for laws banning males from female sport, or laws keeping males out of women's prison, or bathroom laws?
Well, what I think is that it helps us with those struggles. We at Wolf, we've been working on prison litigation because in some states, all that has to happen is a male has to say, I identify as transgender, and they can be put into the women's facility. And of course, there have been rapes and pregnancies and sexual assaults, and the women just don't feel comfortable. So I think what this does is it doesn't come out in the majority and say it, but at least it's recognized in a concurring opinion that, yes, sex is something. Sex matters, and transgender is not in the same level. Because think what would happen if gender identity was subject to intermediate scrutiny like sex is subject to intermediate scrutiny. And then women want to make a claim that there's men in our private spaces, but gender identity would come up and be equal to that. And they'd have to balance that and work that out. So it'd be very difficult.
Yeah, and incoherent. I mean, you wouldn't have rational
Right.
classes of people anymore.
Mm-hmm.
So, all right, I'm going to go to Glenna. Tell us about Sotomayor's dissenting opinion. What was her very measured argument?
So Sotomayor's argument was more measured than what she put forward at oral argument, which is good. I mean, coming out of oral argument, we were thinking, oh my gosh, she's like so angry. She seemed like she was trying to tee up like these kind of made for TV moments, which she was successful in. And she casually referenced people choosing their sex. So her written opinion is more cleaned up. And it's so of course she's arguing the opposite point, and she goes all the way and saying these laws do discriminate by sex. They do discriminate against transgender people. Transgender people, that is a real class, a rational class, and they are entitled to intermediate scrutiny. And then she finishes off saying, and that she would strike down the state because it can't pass intermediate scrutiny. And just one thing to note about that, so the other two liberals sign on to her opinion, except that Justice Kagan does not sign on to that last piece where she says, I would strike down Tennessee's law. Justice Kagan says, well, I don't know. I mean, I would subject it to heightened scrutiny, yes, but I don't know whether I would strike it down. I would need more information about it. So you can kind of tell that Justice Kagan is a little bit more operating in the real world, and maybe has read some of the articles she's read, her colleagues' opinions in this case, and she says, okay, there's a little bit something to worry about here. But still, I think that transgender people are a real rational class that deserves heightened scrutiny. So back to Sotomayor. So, we make fun of her a lot. She does make some decent points here. The reason she's able to make the decent points is because she's reacting to Robert's majority opinion, which is not perfect. It is sort of you can tell there's political compromises at points, and that he's kind of pretends the issue is simpler than it is sometimes to reach a certain point. So, for example, Justice Cypher talked about Amy Coney Barrett's really interesting concurrence about heightened scrutiny for transgender people and why that cannot work. Justice Barrett's opinion there is kind of brutal. There are kind of three elements to examine. The ACLU would need to show all three about transgender people, and Justice Barrett finds they can't establish even one of them. So it's I was watching a liberal podcast earlier, and they called her concurrence gratuitous. They were so upset that she wrote it because why would you be so mean? And there's no reason to say it. You could just not said it. And I bring that up to say that I think Barrett was right, and the other dissenters, the other concurrence is as well, in saying, look, the majority should have touched the question of whether transgender people are a suspect class. And the reason they should have gotten to that question is because this law totally does distinguish by transgender status, whatever that means. I mean, if you accept that has any definition at all, which all the justices do, and I might not, but if you accept that, then of course this law is distinguishing that way. That's what the whole point of the law is. It's really the legislators are trying to target this group of people, which they think is kind of real. So you have Justice Barrett and Thomas and Alito saying, look, we would go there. And Sotomayor sees all that happening, and she's like, yeah, they're right. And the majority is wrong, and they've kind of cut a corner and made it easier for themselves by not going there. And Roberts probably didn't go there because he wanted to keep his 6-justice coalition intact with Justice Gorsuch, as we've discussed, who might be committed to that principle. And maybe, I think Justice Kavanaugh also might have preferred a mild opinion to a stronger one, because that oral argument, Justice Kavanaugh was kind of tearing his hair out and saying oh my gosh, I'm so worried that no matter how we rule, we're going to hurt people. So because of political compromises like that, Robert's opinion is not perfect, and Sotomayor is able to kind of seize on that and makes some good points. So, for example, he also says that Tennessee has not offered evidence to show that it's more dangerous to receive puberty blockers for gender reasons, basically, than for other conditions like precocious puberty. And she kind of rubs that in their face because it's true. It's not totally articulated in this case why it's worse to prescribe these things for one condition or another. Now, the majority says they don't need to articulate it. They just have this really low burden to meet. But it's still kind of interesting that they don't. And this comes back to just a problem that our side has in general, where for some reason they're sometimes squeamish about putting forward the real reasons, which are these medications, so-called medications, are super dangerous, and the condition they're treating is not real. Our side often doesn't want to be that blunt, but that's what's going on. So when you're comparing it to precocious puberty, they're medically different because you're talking about the kids receiving the drugs at a different age, so there's a scientific difference, but also precocious puberty is a real problem, and gender dysphoria is kind of concocted by sexologists and to stigmatize or to drug gender nonconforming kids who will grow up to be gay. So Sotomayor notices these weaknesses, she seizes on them, and so for that reason, I think as much as we make fun of Sotomayor, I don't think it's wise to just say her entire opinion is garbage. I think, well, she makes some points. It doesn't really matter because she lost in the end, and hopefully she will be in the minority, for a long time before until this fad passes. But I just want to give you a sense of kind of what's going on there. And she also, interestingly, so we were talking about whether this affects other issues like bathrooms and sports. And the majority is clearly just trying to avoid that whole situation by saying, like, no, we don't want to go there. They almost seem to be constructing their logic backwards from that outcome. Like, we don't want to end up doing that. So we're going to kind of articulate this argument that wouldn't go there. And it seems obvious to us that you don't want justices giving heightened scrutiny to these laws that basically protect women, like relating to sports and bathrooms. But Sotomayor, she goes right at it. She's not one of these liberals who avoids that question. She says, yeah, we should give heightened scrutiny to all those laws. She says, looking carefully at a legislature's proffered reasons for acting, as our precedents demand, is not second guessing, and she's quoting the majority, and it's not judicial encroachment on areas of legitimate regulatory policy. She says that it's the court's job to do that. So she wants to give heightened scrutiny to Title IX, and that's really scary, except for the fact that she is in a small minority on the court.
So, I'm a little confused by the process. So, yes, they didn't bring in the issues around, say, puberty blockers that you mentioned, and so she brings it up because it's by avoiding it, it becomes a weak point. But I mean, isn't there? There's no discussion. There's no back and forth. There's nothing in the process where they would go through that. They're all kind of operating in their own little judicial worlds where it's all there's no opportunities for that.
Well, there's certainly back and forth. You can see that especially in footnotes where they try to engage each other's strongest points or the ones that stick out to them. But, that's just an example of where I think she picks up on something that is a little bit of a flaw in the argument. Oh, and I want to point out that she talks about interracial marriage. So this was a big point of oral argument because Justice Ketanji Brown Jackson brought it up 4 times when she's dealing with only 3 lawyers. So these guys love to compare our position to people who are against interracial marriage. And they just bring it up in all these different ways, draw whatever kind of crazy analogy they can. And in Sotomayor's dissent, the way it comes out is she says, well, in that case, back in 67 or whatever it was, the state argued that they had experts on their side saying that it was like dangerous to allow black and white people to marry each other. So that's just like here where the state says they have experts on their side.
Oh.
And so that's completely absurd. And I just want to make sure people know that she is crazy.
Okay. Okay. So when this case went before the court, President Biden was in office, and his administration actively promoted gender affirming care, and his Department of Justice joined the ACLU in suing Tennessee. So now we have President Trump, and he's withdrawing federal funds from hospitals that carry out these procedures. In response, Children's Hospital of Los Angeles recently announced it would no longer provide puberty blockers or cross-sex hormones to minors. So, Kara, does the outcome of Skrmetti, is it still relevant when we have a president who's already kind of laying down the law against these interventions?
So I would say, just on the topic of the medical interventions, yes, it's definitely relevant, at least to the extent that you could easily have private providers who don't get any federal money in Tennessee or another state that does this. So they're not at risk of losing any federal funding. So this is important for protecting kids in those states. Because the laws prohibit all providers, whether they get federal funding or not, from administering these medical interventions. On the broader topic, which we've kind of been going back and forth on a little bit, does Skrmetti matter for the purposes of determining whether so-called transgender people constitute a quasi-suspect class? This is one of the areas in which I'm extremely frustrated with the majority opinion, because many of us wanted a really clear, strong opinion, which the Sixth Circuit gave us, that so-called transgender people do not constitute a quasi-suspect class for equal protection purposes. And the ACLU argued before the Supreme Court, the Biden administration did it too, but it sort of underemphasized the argument because I think it knew it was a losing one. So I really wanted a very clear majority decision saying that so-called transgender people do not constitute such a class for equal protection purposes. And we did not get that. So, and as Judge Cypher was saying, Justice Barrett's concurrence, in my view, Justice Barrett's concurrence is my favorite opinion in this whole thing. I like Justice Alito's for a lot of reasons. I like Justice Thomas's for a lot of reasons, but I really like Justice Barrett's because it's very clear and it's very succinct. And as said, it just makes the argument crystal clear that so-called transgender people are not a quasi-suspect class for equal protection purposes. And as Judge Cypher said, that can be used going forward. So, for example, well, so going forward, in cases involving female-only sports and spaces in prisons, Justice Barrett's concurrence can be used in legal arguments in support of women and girls as a sex class. So that's good. But her concurring opinion isn't precedential. So that's why it's kind of a bummer that the majority wasn't willing to go there. Yeah, I think I sort of lost my train of thought.
Yeah,
Oh, so, like, for example, there are two cases where we're waiting to hear from the court about whether they're going to take a case involving a state law that protects female-only sports. There's one out of West Virginia, there's one out of Idaho, both lost before the pertinent courts of appeals. Both states have asked the Supreme Court to weigh in, and we're still waiting to hear if the Supreme Court's going to do that. And if in Skrmetti, the court had said, look, so-called transgender people are not a quasi-suspect class for equal protection purposes, that would be really helpful in determining the outcome of those cases. Now, maybe they're waiting for one of those cases to weigh in. And in his dissent, Justice Alito argues this point. He says he says transgender people are not a quasi-suspect class for equal protection purposes. And he notes in a footnote, he says something like, we are going to have to decide this at some point. He's like, he's kind of annoyed that the majority kicks the can down the road. And he says, we're going to have to decide this because the courts of appeals are all over the place, and cites a bunch of cases that many of us are familiar with, where some circuits, like the 11th Circuit, have said that schools are allowed to maintain single-sex bathrooms, and others, like the 4th Circuit, have said that schools are not allowed to maintain single-sex bathrooms, and it's kind of a mess. And I think Justice Alito's right that the Supreme Court has got to do that. So on that question, Skrmetti is not particularly helpful in my view, even though the very strong concurring opinions can help us make our arguments.
and do you think they avoided it for this political reason that they wanted to maintain their majority?
Yeah, I mean, yeah, in 2020, in the Bostock decision, Justice Gorsuch, as Judge Cypher said, Justice Gorsuch just threw out the idea that discriminating against a person on the basis of transgender status constitutes unlawful sex discrimination without telling us what transgender status means. And he's going to have a really difficult time explaining himself, although he had an opportunity to do it here and he didn't. And we can't really speculate about that. But yeah, I mean, I think both of the other speakers are right. In order for Roberts, who cares a lot about the institutional credibility of the court, and he cares a lot about having strong majorities, I think maybe he thought he wasn't going to get a 6-vote majority if he went there.
And the other aspect of this, so obviously the states that have passed bans or are going to pass bans are protected by this ruling. Is there any impact in the states that don't have bans? If a clinician, anything about, like the right not to treat, would that be protected?
I don't think that was even really at issue here. So I would say no. I don't know if Glenna or Judge Cypher has an opinion on that.
Yeah, I don't actually. The right not to treat, that's going to be framed differently for the doctor and or the therapist or the endocrinologist or the surgeon. So that would be a whole different kind of argument. This would move us back into what is gender identity anyway. Is it part of your soul? Is it a quasi-religious experience? So I don't know the
I mean,
answer.
couldn't they use the argument that, well, I'm not discriminated against my patient because of this decision?
Well, this decision is limited to saying basically a state can regulate medical care for children.
And that
So
can't.
that's really all the majority ends up saying. And so that would mean that if the state banned it, it's banned. If the state didn't ban it, then the doctor, whoever the clinician is, they're operating more, as long as it's not affirmatively mandated, like it's not specified that you have to give the care or anything like that, then it'd be a state by state thing and more personal to the medical associations
Mm.
and the doctors.
Okay, and then Glenna, you argued that there's a consumer protection case to be made by detransitioners. They were misled by clinicians about the safety and efficacy of these gender interventions. So how might this ruling affect that argument?
Well, this argument, this ruling is not directly on point. It's like a different area of law. And I think that you might see snatches of this opinion kind of quoted in other types of lawsuits. So, where you have the majority saying something's kind of negative about the state of the evidence or whatever, you might see that quoted in a helpful way. But it's not directly on point. I do want to address the issue of just doctors discriminating against patients, because I've been following this a bit, and it's wild. And it actually does have. So what's going on is that a lot of the blue states have state laws, either statutes, so it's different from the federal constitution, but they have these civil rights statutes that say you can't discriminate against people by gender identity. And some of their attorneys general in big blue states are saying that if a hospital or an individual doctor, they don't say individual doctor, they say like if a hospital stops treating so-called transgender people, including minors, then that is discrimination against the patients by gender identity under their state law. And they draw an analogy implicitly to a situation where a doctor is kind of refusing to treat a Black person when they treated a white person for the same medical problem yesterday, which is obviously horrible. But that's the analogy that is being drawn for these doctors who, in a very different situation, they don't want to give a mastectomy to a 13-year-old that's cosmetic when just because they gave a mastectomy to a 50-year-old with breast cancer yesterday. So that's like this crazy analogy that state attorney generals are making, and it actually has like the same logic as the ACLU's argument in Skrmetti, which is, well, there's a right. There's a right to this medical care, and anybody who is not on board with this right, they're violating some civil rights law, whether it's the Constitution or a state law. And this is wild, and it hasn't really been sussed out in court. I think it shares the same DNA, and yet it is so much more intuitively offensive when they hear it, that an individual doctor is kind of forced to provide this procedure. And I'm really curious if that starts playing out at some point.
And we have, like Children's Hospital LA, the Attorney General is demanding that they resume this care. But, it seems like aspects of this ruling would be beneficial if they don't want to be forced to provide this care. I mean, I don't know what their thoughts on it are, but in order to preserve funding, like, does anything boost that case? It would be strange in a blue state to be arguing that Skrmetti somehow helped them to not provide care. I don't know if that's.
Yeah, it's not directly on point because we're talking about these state statutes instead of the federal constitution, but you can see hospitals kind of quoting the logic of Skrmetti, perhaps.
Okay, Kara, does this ruling have implications beyond gender medicine? So if a case came before a court involving the sports issue, trans-identified males in female sport, will we see that same thing with quotes being applied? And maybe this is more relevant because of the sex discrimination aspect of it.
Yeah, I mean, this is sort of why I wish the court had taken the opportunity to rule that so-called transgender people are not a quasi-suspect class for equal protection purposes, which is one of the main things that Women's Declaration International USA argued that it should. But again, we're waiting to hear if the Supreme Court is going to take up
Right.
either of the two sports cases, and if they do, maybe they'll do it. I mean, I will also just say on the topic of whether Gorsuch can get around his very ill-advised majority opinion in Bostock, the WDI USA amicus brief tried to give language that the court could have used to sort of finesse that issue. They could have said something along the lines of, oh, when we said transgender in Bostock, we meant something along the lines of people who don't conform to sex stereotypes. They could have said something to at least explain what they meant. And they didn't take that opportunity to do that. So, we'll see what happens. But again, the concurrences provide a lot of really great arguments that can be used in future litigation. I also just wanted to say real quick, there was a right not to treat case that came out of Texas in which two doctors sued. This had nothing to do with the state law banning puberty blockers, but it did have to do with providers who did not want to be forced to provide, the kinds of medical procedures that we're talking about. There's one doctor who had a patient who is a guy who refused to be screened for prostate cancer because he insisted that because he identified as a woman, he could not possibly have a prostate. And this really alarmed the doctor, who wanted to be able to provide care to his male patient. And there was another doctor who does provide so-called gender-affirming care to adults, but has a categorical ethical position that she won't do it on kids. And they were both afraid that if they proceeded with their own medical practices and protocols, that they would have their federal funding yanked. And they won at the district court level, and then the Fifth Circuit knocked it out because the Fifth Circuit said they didn't have standing. But there is some precedent, right? And there's a very solid district court decision in that case that doctors do have a right not to provide so-called gender-affirming care under certain circumstances when they think it's not appropriate.
Yeah, I do they know that? Because
That I don't know.
I'm not convinced they do. Okay, and then a question for all of you. Was there anything that surprised you in today's ruling? I think most of us assumed it was going to go in this direction. We were one step past hopeful. So, but was there anything in particular about the ruling?
Well, let me just say something because I'm going to have to go in a minute.
Yeah.
I was surprised at how mild the majority opinion was, how it really turned out, to make this a tiny issue where it was a huge issue before. And I was really hoping, I would have loved to have seen Judge Barrett, Judge Thomas's opinion, together as one strong opinion. So I was surprised that they didn't come to grips with the real issues that everybody was trying to raise. But that's how it goes. Thank you for having me. I am going to have to go, but I'm sure I'll talk to y'all soon.
Yeah. Thank you for joining.
Thanks. Bye.
Bye.
So I don't know if Glenna wants to go, but I definitely agree with Judge Cypher. Look, most of us wanted the Supreme Court to affirm the Sixth Circuit, and that's what it did. And I'm very, very happy that it did so. This is an important win. But I was disappointed by the majority's reasoning.
Okay. So just not a big enough statement on the reality of this issue.
Yeah, not a big enough statement. And also they didn't do what I wanted them to do, which is rule specifically on the quasi-suspect class issue.
Yeah. Glenna, anything surprised?
Yeah, I agree with the previous speakers, and I will just add a specific point. I did not like the use of the term sex transition treatment, which is what Justice Roberts and the majority used, and also I think Justices Alito and Thomas, they all use that term. Of course, sex does not transition, and this is especially problematic since they, the majority did not define sex. So we're really reading tea leaves to see what is sex and does it change? I want to learn. And unfortunately, that is not settled, and that's actually been um, that problem's been reinforced by the Supreme Court using this language. It's something that I've noticed a lot in our circles. It tends to be like conservative media will say child sex change. I think they do it because it sounds shocking and they're trying to shock, but I really don't like it because, of course, I'm a stickler for accuracy, as we all should be. So that drives me nuts. But on the bright side, I will note that Justice Barrett did not use that term. She avoided characterizing the treatments at all. She would just call them, opposite sex hormones or something like that.
And can you foresee a case hitting the Supreme Court that would force their hand and where they'd have to start defining these terms and they'd have to be specific, with their language?
The passport case, if you guys know that, Orr v. Trump, which was filed because Trump's, he had the State Department order that all the passports get rid of their non-binary markers and have sex markers for people, not gender identity markers on the passports. So you challenge that. They're doing great in the District of Massachusetts. And of course, and that is a case where they're really grappling over definitions. And, often the ACLU tries to avoid defining sex. But that is one case where they put forward a definition. And it's a really funny one because, first of all, they imply that sex is different in different contexts, borrowing from a kind of a sort of, what should I call it, like a queer theorist in Brooklyn. This idea that sex is different depending on context, especially depending on government agencies, and that for the sake of the State Department, it should be this definition which they have basically drawn from Harry Benjamin's 1966 book, but they pretend is cutting edge, which is like sex is this hodgepodge of characteristics, and there's like 8 different types of spectrums, and you kind of add them up and divide by 7 or something. So that is a case where the definition of sex, and of course, Trump himself defined sex in the executive order, and then HHS did later on. So that is a case where the definition is being discussed.
Okay, so that may force their hand, and that will force their hand, at least for some quotient of these terms, this terminology. So for Kara, I want to digress just for a moment. Mention that a bill called the Protect Children's Innocence bill is advancing in the House. I don't know if anybody watched that hearing, but if you want to spend some time yelling at your computer, I highly recommend watching that hearing. It would criminalize providing gender interventions for minors. So, what are the chances? So it's not going to pass, right? This bill isn't going to pass. But hypothetically, how does it fit into today's ruling that states can regulate these procedures if we have a federal act that criminalizes them?
Yeah, so setting aside the likelihood of it passing given the makeup of the Senate, Congress needs authority to legislate. So congressional authority is located in Article 1 of the Constitution, and it very frequently relies on something called the Commerce Clause, which says that Congress has the authority to regulate interstate and foreign commerce. And this bill that you're referring to contains numerous references to interstate and foreign commerce. So it's pretty clear that it's that clause on which Congress or the Republicans are relying to advance that legislation. How would it affect it? I mean, if it were to get through, then we wouldn't need state laws like Tennessee SB 1, I think. That's my read of it.
Okay, so so that would override anything that the court has said about this ability to legislate from the state.
I guess, I mean, this is one of the realms in the whole sex and gender debate in society with which I'm least familiar, because I'm on very shaky ground when we start talking about the administration of our health system, regardless of whether we're talking about sex or gender or diabetes or cancer. Like, I just think that there are very complicated mechanisms at play when it comes to the administration of our health system, very complicated relationships between like Medicare and Medicaid and state governments. And I don't really understand that system. So when we start to talk about relationships between the federal government and state governments around the administration of healthcare, I start to get very lost in the weeds. Because even though I'm very much in support of Tennessee's SB1, and I'm very much in support of similar state laws, I don't really know how our healthcare system is administered. So it's very difficult for me to navigate like really specific in the weeds questions like that.
I mean, I think about, how would you implement that? How would you impose that if you have a state that says we're not going to follow that?
Well, I mean, okay, so if we want to talk about conflicts between blue states and the Trump administration, I mean, the blue states and the Trump administration are headed for some very serious litigation on a whole host of issues when it comes to these kinds of things, whether we're talking about laws like Tennessee's SB1 or laws like West Virginia's Save Women's Sports Law. I mean, the Trump administration and the blue states are just really butting heads on a number of issues. And basically that was a long-winded way of saying we're just going to have to let them fight it out in the courts.
Okay, so it'll keep going back to the courts.
I presume as much.
So that's the Skrmetti decision. The court has yet to issue its ruling on another case of interest to our group, which is the Mahmoud v. Taylor. And that case involves parents in Maryland who sued the Montgomery County school system for mandating that their young kids had to participate in readings and discussions of, LGBTQ inclusive storybooks during class time, and the parents could not opt out. So the parents argued this violated their freedom of religion. Glenna, does the ruling in Skrmetti tell us anything about how the court will rule in Mahmoud v. Taylor, other than that, we'll probably see this kind of ideological split between the conservatives and the 3 liberal justices?
Skrmetti kind of confirmed what I was thinking going into this after oral argument in Mahmoud, which is a couple of things. Justice Amy Coney Barrett is starting to get her head around this issue, I think, more than even Alito and Thomas were getting more attention. Like Kara said, that was a strong opinion that Barrett wrote, and it looks like she's thinking hard about this in a very shrewd and legalistic way, which is helpful. Just any kind of hyper analytical thinking on the subject is always good. So, and she was also asking really sharp questions at the Mahmoud oral argument, kind of contrasting gender identity lessons with math lessons and saying like, this is all just a theory. So I'm optimistic about her going into Mahmoud. And also, we were all thinking coming out of Mahmoud that Justice Kagan might peel off from the liberals because she was skeptical of these books, and she made a remark like, oh, even non-religious parents might be concerned about this. So, and remember in Skrmetti, she peeled off from the liberals just a little bit where she said, I would apply heightened scrutiny, but I don't know whether that would defeat the law here because there might be good reason for banning these treatments for minors. So it makes me more hopeful that maybe we could see Justice Kagan lining up on the other side. With that being said, I have mixed feelings about Mahmoud because I'm a secular person, and this is about expanding religious rights, and it's on a political level, it frames things really poorly for our side by making it all about religion and mashing gay and trans issues together. And the parents who are so-called on our side or were very aggressive in mashing those issues together. So for a lot of reasons, I don't like saying unequivocally that I'm like in favor of a certain outcome in Mahmoud. But anyway, that's my analysis.
For that ruling, does can the ruling expand beyond the religious aspect, even though it is a religious rights case? Could the justices expand their session?
Well, I suppose the way they would, well, there's a few things. So on a practical level, it's possible that just giving more religious rights would make the schools, make it too much of a burden for the schools to like distinguish between who's religious and who's not. So the schools themselves might go beyond the ruling and just be like, if you want to opt out for whatever reason, here's the form. We're not going to like ask you if you're religious. So that's one way it would ripple out. And then for the court directly to help out non-religious parents, probably not. I think that would require them to kind of define religion, and in a way they've avoided defining it before, to say like, oh, by the way, this includes freedom of conscience or something like other countries have. And they're probably not going to do that. That would be a big deal.
Okay, we're limited. Okay, so I'm going to ask you both a final question. So the Democratic Party has promoted the demands of trans activists as the next frontier in civil rights. So in essence, the activists are insisting on a supposed right to identify out of sex, out of the reality of their sexed bodies. So from this, Flo demands that children get off-label harmful drugs and surgeries. Males compete in female sports. Male felons be housed with female prisoners. So does this ruling strike a blow in the broad notion of transgender rights?
Well, I mean, yeah. I mean, I will say, one very sort of strange aspect of most of the decisions, most of the opinions in this case, including the majority and including Alito, they sort of seem to assume that transgender, like Alito just uses the phrase transgender people. And presumably he thinks he knows what he means by that, but he doesn't really tell us what he means by that. But at the same time, sex, like the concept that sex is real, was not stated explicitly in the majority opinion, which was another disappointing aspect. I was looking forward to a ruling that was more like the UK's April ruling that said that sex is clear and biological. We didn't get that. But the idea that sex is real kind of still runs through the opinions anyway. I don't know. I'd like to hear Glenna's take on that. But in any event, again, this majority opinion, I was very disappointed in for a number of reasons. But again, we wanted the Supreme Court to affirm the Sixth Circuit. That's what it did. It's a win, and I'm happy to take it. But I think that we've sort of built a little bit we've got like one more building block to say that sex is real and that it matters.
Okay, Glenna, you want to weigh in there?
I agree with Kara, including in being sort of open to like not entirely sure what's going to happen. I do wish it had been clearer, but I agree that there's sort of a thread that assumes that sex is real in the conservative opinions and that it's binary and doesn't change. Bostock used the language sex identified at birth, which is pretty much the same as sex assigned at birth. And the majority today and the other conservatives do not use that language. So that's a good sign. I mean, we're talking about this war over the reality of sex, which Kara, kind of taught us all about, writing books about it. And then in the gender critical world, we're very familiar with the idea that the ACLU is trying to just abolish sex. The justices do not know that. Most normies, including conservatives, don't realize that's the train we're on. And it's like that big picture is just not seen by a lot of our fellow Americans, including ones who are pretty educated. And I don't know, it's awkward. I mean, I wonder if we're somehow going to get through this entire crisis without people realizing how close to the abyss we came. Like, it's kind of funny in that sense. I mean, we can zoom out and look at what's going on in the advocacy world. So it looks, especially from a New York Times article today and also from some other sort of rumors, it seems as though everyone in the trans movement and is trying to throw Chase Strangio under the bus. And Chase Strangio has become the avatar for this idea, which I don't think she came up with on her own, but the idea that, we should abolish sex, basically, and that it should just be entirely self-ID and, no women's rights, all of that. Like, Chase Strangio really stands for that and has been pushing for that, even though I don't think she came up with it herself. And I think it predates her at the ACLU. But symbolically, people are going after her. And I mean, maybe the ACLU will be pressured to back off of the sex abolitionist stance. Now, if it does, I don't know. There's no, there's no normal way to argue for transgender rights. The entire system is based on sex denialism. It's more obvious when it's done in a Chase Strangio way, like talking about non-binary identities. Um, but I mean, knives are out and people are talking about it. The New York Times article today, I had a lot of problems with it, but it did get closer to the truth than we have ever seen the New York Times get in terms of the question, like, what is sex and where are these definitions coming from? So I think the dialogue is progressing slowly toward a place where people might understand what's going on. And if they do, then most will oppose it, especially the justices of the Supreme Court.
So that was going to be my next question, kind of, which is what does this mean for Chase Strangio and the ACLU? How are they processing this loss?
They are saying that they will keep fighting, that they see avenues for litigation. I wrote about this a little bit in a post today at Bad Facts. I think avenues do exist, like not good ones, the writing's on the wall, but the ACLU, like what they do is they go to court and they fight about constitutional issues and they try to get to the Supreme Court. Like that's just what they do. That's how they make money. That is why people donate to them, because they want to see the ACLU argue about trans rights at the Supreme Court. So like they're just going to keep doing that. Like they almost have to do that. And they can try to focus on other areas of trans rights, but they all, all of them trace back to this idea that all the ones that the ACLU wants to fight, they all trace back to the idea that sex isn't real. They don't want to move back to the position of just saying like you shouldn't be fired from your job for saying that you're trans. They don't want to argue that case. So they're, I mean, maybe they have a giant reckoning. Maybe some of their donors drop out. Some people speak about the ACLU's operations very confidently. My theory is that there is just, I mean, I've analyzed them a lot, especially in terms of the arguments they make and somewhat in terms of their funding. But I just think there is a big component with them that we do not know, that history will like unspool that story for us over the next 10, 20 years. But like there's something weird going on at the ACLU factually. I don't know what it is. It's kind of a mystery.
The other aspect to this that I just notice more and more is how nothing seems to penetrate the minds of liberals on this. Not all liberals, obviously, not us, but the believers, that it's always 2019, and this ruling is going to be viewed as conservatives hating, bigoted conservatives hating trans people, and every systematic review is really just garbage, and nothing penetrates. And we saw this with the justices here, maybe not Elena Kagan, but the other two liberal judges. Is this our is there no breaking through? Do you see signs of breaking through? I mean, we talked about Elena Kagan, but otherwise, then we had Democrats, in numbers coming out and making statements about how tragic this ruling was. Nobody took a step back. I mean, I guess not everybody did, but they're not making statements like, maybe we should think about this a little bit, right? They're staying silent, or they're coming out and talking about the tragedy of the Skrmetti ruling. So do you see anything out there, or any explanation for why we have this wall, this impenetrable wall?
I mean, I think that there are definitely some true believers. I think that there are a lot of prominent Democrats who know what's going on, but they're just so dug in that they're hoping they can just keep deflecting. If they think that if they just keep deflecting and ignoring the matter, then it'll go away. That's what I think about the Dems in power. There are some, like when I went to DC a couple of months ago and met with some of the Senate Dems and their staff, and like some of the incoming, the newer members, I was there in February, so they had just gotten there, and the ones elected in November 2024, a lot of them truly still have no freaking clue what's going on. But I mean, Elizabeth Warren had her little tweet about trans kids, and
Yeah.
the big ones, the big ones are just true believers, and they're never coming back. It's the people who know what's going on but think they can deflect forever that kind of irritate me even more.
Yeah. Okay, well, that covers all of my questions. Let's see if we have any questions in the audience. All right, Emmy Pinkhurst, we're going to elevate you to speaker.
Hi, good evening. Thank you for this space, and thank you to the speakers. This has been really enlightening, especially from someone who does not have a legal background. It was mentioned briefly before, but this notion of trying to raise this at a federal level in the House and in the Senate, I couldn't help but notice among everything I was seeing on YouTube last night, of course, Matt Walsh talking about this and, crowing over it, I guess you could say, as some sort of a personal victory. But anyway, that aside, would there be any merit, do you think, even if it was not going to get all the way through and be passed? Do the panel think that there would be some merit to forcing, members of the House and members of the Senate to go on the record on, their opinions about this and have to argue it out in public? Thank you.
Glenna, do you want to speak to that?
Sure. I think we kind of know where legislators stand, unfortunately. If I could have one bill put forward just for the sake of getting people on the record, it might be the two sexes bill. Just, saying that the federal government defines sex XYZ and make them talk about that.
I mean, we've had that, right? I mean, that's the Protection of Women and Girls in Sports Act. And we heard what we heard what everyone thought about that during the hearing in January, in which my partner was sitting next to me watching the debate, and his observation was, "Oh my God, why do the Republicans all sound like normal people and the Democrats all sound like they're in a cult?" Right? Like we we heard what the Democrats think of defining sex accurately, at least under Title IX.
Yeah, unfortunately, I don't think there's any question, and that's what's surprising is that there doesn't seem to be public wavering, but maybe there's private wavering. Anybody else? Any other questions? Questions about the ruling? If not, we're going to thank our guests and wrap up. Thank you to Justice Cypher, who had to jump off, and to Kara Dansky and Glenna Goldis. If you haven't already done so, please join DIAG by clicking the Join button at di-ag.org. Our power to reach our lawmakers is through our numbers. It's important to show that we're a silent majority who believe in classical liberal principles, following the science, including the reality of sex, ethical, evidence-based medicine for all, the power of civil discourse and open dialogue, advocating for the rights of women and girls to sex-based spaces, honors, and opportunities, LGBT rights, and the necessity of a compassionate, reality-based society where truth matters. So thank you again to our guests, and thank you all for joining us. Have a good rest of your evening.